Josh was trying to issue two of them.
Okay, I'm recording.
Oh, okay. Hello.
All right, we're not quite 8:30 yet. There's Pat.
Good man. Well, it's like, oh, my dad always used to say this.
Yeah.
You got me.
Hey.
Oh, I don't, of course, you can't use the toothbrush because it was the teeth cameras on, but no, I'm kidding. Well, there you go. Yeah.
Okay, good morning, everyone. I'm Chairman of the Board, Darren Hamilton. I'm going to call this meeting of the Jefferson County Board of Supervisors to order. First order of business is acknowledge the minutes from the previous meeting.
Second.
I have a motion from Dimmitt, a second from Sandquist. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. We still don't have Sandy Stever or Scott Klein in our office, so we'll go ahead and move on to consider resolution to raise wages for secondary road department employee. We have Jared Porin, who is an EO2 at a pay range 12. He'll be at step C with a base rate wage of $25.20 an hour, with an extra 10 cents per hour for longevity pay, for a total rate of $25.30. I have a motion from Dimmitt, a second from Sandquist to approve this resolution. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. All right, continuing on, consider a resolution for the Jefferson County bridge load posting in year 2020. This resolution states, whereas the Jefferson County Board of Supervisors is empowered under the authority of the Code of Iowa, section 321.236, subsection parent 8, 321.471 to 321.473 to prohibit the operation of vehicles or to impose limitations as to the weight thereof on designated highway structures under the jurisdiction, and whereas the Jefferson County engineer has had the following bridges inspected and determined that restrictions should be designated based on the present structural conditions. Be it resolved to adopt the Jefferson County all load posted bridges for 2020 ratings as proposed by Calhoun and Burns Associates yearly 2020 bridge report to use as the legal weight and load limit for structures in Jefferson County, as shown in exhibits A and B attached to this resolution. So do I have a motion to approve this resolution?
Second.
I I have a motion from Dimmitt, a second from Sandquist to approve the resolution. All those in favor say aye. All those opposed, same sign. Motion carries.
Hold steady.
Yeah, we're pretty much the same as it has been. There's that one. Okay.
Fixed all your bridges just now.
Yeah, they're all posted at that, and normally we just do the changes, but I had them give me a list of everything that is posted and all in one list.
Doesn't look like there's any changes on that list.
Well, the changes really happened in the, right after they did the inspections.
Right.
So they're all posted for what the inspections said.
Okay.
Okay, we'll move back to meet with our county engineer, Scott Klein.
So it's been a couple of weeks. We've done blading of gravel and before the rain, dirt roads. And then blading for dust control on butternut and 1/10. And I believe those have had dust control. Brush cutting with boom mower in District 2. They installed a tanker car on 250th to replace a 10-foot diameter corrugated metal pipe. The bottom of it was all rusted out, and that during a rainfall last spring or early summer, it kind of washed the road out. So that was replaced, and the roads should be opened up again, although I don't know that anybody would have taken it this past week with all the rain. So, maintaining equipment, mowing on, more mowing going on. Let's see. Business Highway 34 to the east, there is like a expansion area or something, concrete in the middle of all the asphalt. There's like 4 or 5 inches of asphalt over the concrete, but this one patch was sticking up. Concrete was creating quite a bump, so they went in and fixed that, replaced it with concrete patch. So I used the total patcher for patching potholes, done rock hauling to spot locations, and sign repair. And the salt, we've got an expansion going on our salt shed. Should double the amount of salt we can put in there. So if it's half acre or something, we can order salt, and we still have salt even if they don't get there for a couple of weeks.
I hate to even talk about this, but we have salt left over last year, and have we already got any contracts for this coming season?
Well, there's sand and salt mix, and then there's just plain salt all in the bigger building.
Mm-hmm.
And when they finish on the expansion, well, then they'll move some of that salt into the salt shed and order more.
Well, we still buy from Ryan.
Yes. Basically, same kinds of things.
He said we got
Asked for it.
butternut and 110. We got Brookville yet.
It isn't written on there. I didn't have a chance to talk to Billy about it. I'll see.
What's it again, you know?
A little over 4 inches.
Yeah.
Yeah, but at our office from the past week when it was raining, it got up a little over 4 inches. So.
Yeah, there's a lot of potholes and gravel roads, but I think they'll probably be able to get back on. So we said that.
Every year, but it tells all the mileage on roads. They were stuck together for some reason.
We got earth roads.
Yes, we do.
So is this changed any?
Oh, it changes when we give the annual report on, say, paving of 227, Osage Road paving and stuff like that. It takes, and when we submit the asphalt resurfacing, then some of the roads, I'm not sure what they do if it's asphalt over concrete, because we haven't had a lot of that till now. So I'll just submit what happened. It'll probably happen, or usually they want those submitted around December or January. And do the updates, and then next year the list will likely look different.
Okay, we've went ahead and approved the resolution for the wage increases,
Okay,
wage increase, and then we also resolution for bridge load postings. So those next two items on our agenda are complete. So anything else to report to us?
I don't have the documentation with me, but Friday afternoon I got a notice that that there's going to be $25 million potentially granted to for bridges.
That would be apportioned all the way through counties that have a shot at that money.
Right.
Or, yeah.
Well, anybody, you have to apply, so they want the application in by the end of September. And when Bill Clemenson from Calhoun Burns Associates was in on the 21st of August, he discussed that was something he foresaw as coming up. And so we talked about a couple different bridges that he might want to apply for. Now they'll only allow us to apply for one. I saw this friendly information on Friday, so
Okay. We'll get that application in by the end of the month. All right.
We have a match.
it'll be a match. And we don't know the percentage of match. Don't know how many counties will want a bridge. There's, the 25 million doesn't go very far with 99 counties.
Right.
There may be some counties that don't apply at all.
But it's important to get us in on that list of counties that have applied. As long as that's in by the end of the month, we'll be at least on the list.
Yeah.
So, all right. We still have not seen Sandy Seaver yet, so we'll move on to discuss and consider budget appropriation decrease. And we have a resolution for that, whereas it is desired to decrease the appropriation to Department 27, Environmental Health, in Service Area 3000 due to lower expenditure projection than anticipated. And whereas the desired reduction is less than 10% of the total environmental health budget and the budget amendment is not required. Therefore, be it resolved by the Board of Supervisors of Jefferson County that an appropriation decrease of service area 3000 in the amount of $7,386 from the Environmental Health Department 27 budget be made. Okay, I have a motion from Sandquist, a second from Dimmitt, and we'll have some discussion on this.
Do you have any idea what service area 3000? The revenue or expenditure projections are lowered, I assume it must be in the salary line item.
That's what I was assuming, that since we did. Yes, there is right here.
Yep.
Right. It wouldn't be from. Oh, it is in the salary.
He had a $90,000 budget.
But his line item for salary budget went from 59,864 to 39,936. So that's where the $7,000 has come from, it appears.
Well, 7,300 is around figure $7,400 is a far cry for $20,000.
Well, yeah, but it looks like he has appropriated different things. Let's see, reduce that one. Reduced.
Yeah, those are the major ones.
Right,
Salary.
right. So we have any more discussion on this? Or should we?
Yes, to me, I'm not sure that, I mean, I see the 82,630 and I know what his original budget was.
Mm-hmm.
I don't understand, I guess, is,
Why only 7,000?
yeah,
When his total budget projection for environmental health was 106,497 and now is 82,630.05. Okay. Yeah, why don't you ask her to come in and we'll hold off until Shannon comes in to get some more answers on this. We do have a motion and a second on the table right now with this. So let's move ahead to discuss and consider reinstatement of disposal system contractor's license for Myers Excavating LLC. Right.
I make that motion for renewal.
Okay, we have a motion from Dimmitt to approve the renewal and a second from Sandquist. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. We have discuss and consider disposal system contractor's license for Pilcher Construction LLC. And I believe I got the same email as everybody else with he had no problems with this. Our county sanitarian had no problems with this. I would accept a motion for approval.
Second.
Okay, I have a motion from Sandquist, a second from Dimmitt. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. Okay. Discuss and consider property tax sale refund. This is from the county treasurer, and we have taxes that were paid of $123 and a certificate fee of $20 and tax sale total of $143. So we're asking for a refund of that. Should we get Mark in here? Yeah. A little explanation on that.
No longer there.
That's right, he told me that. Okay.
All right. This concerns a trailer on the property, and the trailer is no longer there. So I have a motion from Dimmitt to approve the refund, a second from Sandquist. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. Next on our list is discuss and consider fund transfer. This is a resolution, whereas it is desired to transfer $4,788.92 from the Road Debt Service Fund 2080 to the General Basic Fund 0001 due to reimbursable bond expenses paid for from the General Basic Fund, and whereas the operating transfers are in accordance with the Code of Iowa, now therefore be it resolved by the Board of Supervisors of Jefferson County as follows. The sum of $4,788.92 is ordered to be transferred from the Roads Department Service Fund 2080 to the General Basic Fund 0001 effective September 14th, 2020. The auditor is directed to correct his books accordingly and to notify the treasurer of this operating transfer, accompanying the notification with a copy of this resolution and the records of its adoption. The above and foregoing resolution was adopted by the Board of Supervisors of the Jefferson County effective September 14, 2020. The vote thereon being as follows. So I have a motion to approve. Second from Sandquist. Motion was by Dimmitt. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. All right. Moving on, we'll discuss and consider step increase for Anna Davia. Sorry about hammering that name, correctional officer. We have a resolution in the Jefferson County Sheriff's Office, whereas Iowa Code Section 331.903 states that the number of deputies, assistants, and clerks for each office shall be determined by the board, and the number and approval of each appointment shall be adopted by a resolution recorded in the minutes of the board. And Whereas Jefferson County Sheriff desires to step increase one correctional officer salary therefore, be it resolved by the Board of Supervisors of Jefferson County, Iowa, that the Jefferson County Sheriff is authorized to step increase the salary for Correctional Officer Anna Davalia. That I believe we could. They're all three the same amounts. We have a corresponding resolution for Frank Smith's salary and a resolution for Brian Brain's salary. The salary increases on each of these are from $32,500 to full pay of $41,874.26 effective. The effective date of this was August 1st of 2020 for Brian Brain, August 16th, 2020 for Frank Smith, and August 16th for Anna Davalia.
Motion to approve is for him.
Okay.
Second.
I have a motion from Dimick and a second from Sandquist to approve as read. All those in favor say aye.
Aye.
Aye. All those opposed, same sign. Motion carries. Okay, there's these. There we go. Move on to discuss and consider liquor license for the Jefferson County Cider Works.
I'll make a motion for this. I got an email from my contact that this meeting.
I have a motion from Sandquist, a second from Dimick to approve the liquor license for Jefferson County Cider Works. All those in favor say aye.
Aye.
All those opposed, same sign. Motion carries. Okay, we'll move on to discuss and consider courthouse vendor list.
Mr. Chair?
Yes. Sure.
Second one, the main reason somewhat discussion requires the attorneys.
Okay. We'll move ahead before approving, discussing, and considering courthouse vendor list to discuss and consider nuisance properties for non-compliant property owners. So Lee, why don't you start us off here?
Well, I've had discussions with Bruce, Kent, and Pat. And we have, I think, Pat sent out an email.
He had sent that to you.
Actually, what amounts to is 16 properties or cases filed in court. Of those, only 3 have successfully abated the nuisance. Many others are still in the process of doing so. Some have failed to do so and are paying the civil penalties and costs. There is still a final group who have refused to participate in the process at all and have had a default judgment entered against them. So this was put on the agenda predicated upon the request that, or not the request, but conversations that Pat and I and Bruce have had. But we have a problem, and how we resolve that, we've got folks, as Pat indicated, that are paying their fines, but they're not mitigating their nuisance. It's just kind of an ongoing thing. We have folks that never even showed up in court. Now, we did have a property out west of town that ultimately was sold at a tax sale, so we're hoping that that nuisance gets mitigated. The issue I have is twofold. One, long before you two were on the board, we mitigated a nuisance up at East Pleasant Plain in the Boyd property to a cost of $8,000 to the taxpayers, which we've never been able to recoup. Currently, that property has $21,500 of back taxes owed on it. So I asked Pat in an email, no, I'm sorry, and I left a phone message because Pat was doing his job and couldn't talk to me. I find that ludicrous, but I know, you know, it's just amazing to me that county employees, never mind. So we, I wondered whether or not we could acquire the property after it's been up for tax sale and nobody's ever offered to bid on it or whatever, whether or not we can take possession of that property and then in turn possibly through get a quick claim deed where we could possibly sell that property for, not obviously for what's owed against it, but at least recoup some dollars potentially. The other thing is, we as a board have to determine how we proceed against some of these properties. And I will tell you, we have the one that everybody's probably most familiar with is Abington. We have one up in Abington that not only have they not mitigated the nuisance, but they've added to it. So one of the things I also asked Pat was whether or not in this particular instance or any other instance, if we had to remove vehicles or other equipment, farm equipment, or whatever the case may be, whether or not we could take that equipment, say over to Fine Guards, and dispose of it over there and recoup some of the expenditures we have against those properties, if that's what the board decides to do. My take on this, quite simply, is that this is going to be a significant burden to the taxpayers. I don't know how we pay for this. Because even if a property is sold at tax sale, it would be 19 months they have to redeem that property. Assuming, of course, that it would be purchased at a tax sale. We've got another property that is in an estate. We have another property up in that, well, the Boyd property needs cleaned up again, actually. And then there's one right north of the Boyd property. Boyd property belongs to Hugh Hamilton. We've got a big old tree come down across there. The house is absolutely unlivable. But it's not in Hugh's name. And that's on purpose. He pays the sewer bill on it, but the property is not in his name. And so it's somewhat like the Gridley property in Abington. It's in the state. In this case, it's in his deceased wife's name. I don't know how we proceed. That's why I wanted to have the discussion. I wanted to have the attorneys on board with it to see where we could or couldn't go. And quite honestly, if we can't proceed, I mean, I'm grateful for those folks that have taken the steps to mitigate their nuisance, that are responsible enough to do that. But we've got Fitzsimmons property down just north of Van Buren County line. We've got one over in Glasgow. And I'm sure there's a number more out there. I think probably 1008 Oakwood Drive is probably still, I haven't been down there. But
Move stuff around.
yeah. So,
Best way to explain it.
Are you saying it's neater than it was?
Well, piles tend to disperse. They don't leave, they just kind of spread out. So it doesn't look like there's accumulation of as much stuff that was there when you first take the pictures. But when you start looking at the pictures, you realize that, hey, this was here, and now it's over there.
Yeah.
so, and you know, there are, not that this should be a considering factor, but nonetheless, there are some very beautiful properties down there in that area. In fact, the house directly to the east of it is absolutely gorgeous. And I do believe that this tends to affect the value of adjoining property owners as well. So now I'll just throw it out there, the attorneys.
Hey, I've got a question for the attorneys. As you know, we did this process to try to make this more objective. So we're still now coming several months later to the conclusion that we kind of had with the old subjective way, and that some people clean them up and some people don't. And I know in the past it's been mentioned, well, maybe we should just repeal the ordinance, and there's still a state law, and that's my question. What is exactly does the state law cover if we would consider repealing the ordinance? What would the really bottom line difference be?
So the state law is it's the opportunity for neighboring property owners to file a civil nuisance suit and to get a remedy through the courts that way. I mean, I don't know that they'll have any greater success than we will in terms of the resolution. Essentially, in that case, you know, the victim of the nuisance is the neighbor, so they can be compensated at least financially through that procedure. But again, a judgment, as we're learning, is just a judgment. Whether you can collect on that is a whole separate question. But it essentially takes the municipality, the county out of it, and it makes it a private civil claim.
Well, clearly, I think we've been, I feel like with the ordinance and the process we have in place, it's a black and white, which I truly appreciate. It's not a subjective application of the ordinance, it's an objective application. If it meets the definition of a nuisance, it's a nuisance. That being said, I agree with Dee in terms of, that's why I'm asking everybody how we proceed. Now, one of my thought processes, Pat, is that we send out, if the board decides that we're going to move to clean up these properties, that the board sends out a letter indicating that the property owner has 30 days to mitigate the nuisance, or the county will take the steps to, in fact, mitigate the nuisance and charge those property owners, you know, accordingly, whether it's assessed to the property tax or whatever, and assume control and jurisdiction of all property we remove. I don't, Pat, is that legal?
That's in our ordinance.
Okay. So if we do that, and we're giving them 30 days notice to, you know, now we have, I don't think our road crew, I don't think our county engineer wants our road crew involved in it.
I don't believe it can.
And that could very well be, Scott. I don't know the answer to that.
January or so. We'll look at that packet of information, including Attorney General, State Attorney General's opinions and various things. And it doesn't sound like we're supposed to be out off the road doing stuff, even if we get reimbursed for it.
Right. And the thing is, honestly, we don't want our road crew tied up doing these things because they've got other things that need to be done. And that is a whole nother can of worms.
We could do stuff if, say, it's spilled out into the right of way.
Right, which I do have a property over in Batavia that there's a question on.
Yeah.
But that being said, we obviously would have to hire somebody, but we have a property owner also up in Abington that went to great expense to themselves to remove several acres of vehicles and equipment and whatnot and took the steps required to mitigate the nuisance. And then they're sitting here staring across the street at this property where nothing has absolutely been done. So I guess what the board has to decide is whether or not we want to incur that expense and how long, with keeping in mind how long we would probably have to bear that expense. And then there's always, it's like the Boyd property. Do I want to go spend another $8,000 to clean up the Boyd property when I've already got $8,000 against it? Paxton property, there is still some issues with the Paxton property around the corner. There's a right directly east of the Paxton property. There's issues there. We've got a lot of properties out there that potentially we're going to have to go in and clean up. And so one of my original questions, Pat, to you was whether or not in the case, for example, of the Boyd property, where it has not and probably will never sell at a tax sale, but there's $21,500 owed against it, can we take possession of that property?
There's a procedure for the county to take possession of properties at tax sale. I am not, I don't want to talk about what that is off the top of my head because we've never done it before, and so I'm not certain without doing some research on it, but there's a way to do it. And where essentially we become the tax certificate holder. And then, you know, we have the same rights and responsibilities that any other tax certificate holder has. But again, you know, tax deed can't issue for, my experience is a tax deed takes about 2.5 to 3 years before it issues. And so at that point, we could take the property, but that is a long-term remedy. It is not a short-term, get it cleaned up fix.
Right. I mean, we would still have to go in and clean it up, and I understand that. And I keep hammering on the price, but the reason I do is because if we spend another $8,000 to $10,000, now we've got $31,000 against it, with no hope of recouping that money short of owning the property and disposing of it, at least potentially getting $4,000 or $5,000 back. And right now, that process can't be any more long-term than the process we're currently facing, which is that we never have any access to that property. You know, I mean, at one point, the daughter-in-law attempted to make payments on the property taxes, but it just, there's no incentive there because nobody's going to buy it.
Bruce, what are other counties doing? I know at some of the meetings I've done too, just before, after meetings, I'll chit chat with other supervisors, and everybody struggles with the same.
So we enforce the nuisance in the county as well. They've got a little bit more teeth on it because we can do it under zoning. So there's some remedies there that we can take. We've never really had this problem where they just kind of blow us off. We end up in district court, and it's through the zoning provision, and it tends to get handled, you know, that direction. Whereas here, we just have people not showing up to court. We've got people showing up, entering into agreements with Pat, and then it's like out of sight, out of mind. You guys just kind of go on and go about your business. The one thing that Lee's talking about, unfortunately, now that we all know, is this process where you take control of the deed or whatever is the county. The Boyd property would have been resolved by now. You know, this happened, what, 5, 6, 7 years ago.
Well, yeah. Do what?
It would have been longer ago.
Longer than that. It's been many years. Yeah. So, I mean, this would have resolved potentially that issue if it would have started, you know, at the time when it occurred. Now we're let's say 10 years removed from it, and we're back, or the county's back to where it was when it first started. Unfortunately.
Now, I do want to say there have been several that have been cleaned up.
Yes.
We're just talking about the problematic ones.
There's been many people that even when they go to court and Pat entered into an agreement with them, we've got a couple of them that are truly working on, you know, cleaning them up, and we've got a couple before we get into court. Although they get angry and they yell and scream and call us names, which is fine, but they are working on it. So long as they're working on it, we're willing to work with them.
And the other issue is, you know, if I'm a property owner, if I'm the folks that cleaned up that property in Abington. And then have to sit there and look across the street, and there appears to be no remedy for those folks. Then it makes you wonder, well, why the hell did I do what I did?
We have those questions.
You know?
I get a question too, where when we essentially assess the civil penalty in our ordinance, and folks are, you know, not able to pay that all in one chunk, so they're paying it in a payment plan installments. I have had people, more than one, tell me, well, I made my monthly payment this month, so that essentially it's like a fee to the county to allow the property to stay the way it is. That's
Right.
sort of how they interpret it, and I've, you know, affirmed to them that that is not the case. That the payment is as a result of it being that way, but it can't stay that way. But I've had more than one person tell me, well, if I can just pay my $50 or $100 a month and not have to clean it up, you know, I basically bought myself another month and not having to do anything. And that's almost the interpretation that we're getting from some folks.
And if we, I understand what you're saying, but if we, you know, hit them with a second violation, would that maybe get rid of that mindset that, hey, it still exists, therefore now it's $1,000 penalty?
Yeah, I think that, I mean, the ordinance allows for the second violation, as you and I have kind of talked online. We've, you know, I kind of wanted the board to make that decision if they wanted to go with the second violation, particularly for the folks who are making the payments. Because as Lee talked about the expense involved in the county maybe having to go in and clean up, it would be nice to have a little revenue coming in as well. And I really think that if we've hit them with a second violation, the payments are going to stop. So that's a board decision. That's a client decision, since this is a civil case. And so I appreciate the question, but the folks that need to answer it are sitting around the table by you.
That's why I'm asking the question.
So now you said, so just so I am clear on what I think you said, was that as long as Mr. Ringgold is making his payments, we can't go in?
That's not what I said.
Okay,
I mean, if it's a nuisance, it's a nuisance, and it's a nuisance every day that it's a nuisance.
okay.
The question for you guys is, if he is making his payments, do you want to start a second enforcement action that you know, could potentially stop the payments on the first action from being made?
Well, I personally wouldn't necessarily have any problem with that, but I would not be willing to accept payments on the second one. It would have to be paid in full, and I would love to see the court, if it goes to court, the judges, and I know it's not going to happen, state to the property owner, if you don't have this cleaned up within 30 days, you're in contempt of court.
Yeah, you will not get the court to require payment at one time.
Right.
And you won't get a contempt. I mean, I can make an application for contempt, but I don't think you'll get one. And if we lose, then the county's paying those court costs.
So that's why I think, I guess personally, you know, if that's the direction the board wanted to go, okay, I would support that. At least it's moving, but I just think it's spitting into the wind. I just think that, you know, Mr. Rainbow, like you said, as long as he can continue to make payments and the court's not going to require it to be paid up front, this can drag out into perpetuity.
I mean, the court doesn't require restitution to be paid in full. They don't require jail fees to be paid up front. You know, they're trying to work with people to make the financial obligations manageable. So many of the people that we deal with are on limited or fixed incomes. And that, you know, turns into sort of the old debtor's prison type of situation where, you know, it's unequally applied to folks just because of their financial status, and the court isn't going to do it, and it's probably not legal. One of the things that I put in the memo that I sent to you, Lee, was, you know, we can add a criminal violation to our ordinance. And instead of having this be a civil penalty, which, you know, at the time we didn't want to be real heavy-handed. We wanted to encourage folks to clean it up. But for those cases that is not the case, where we're just not having any, we're not getting any traction, you know, we could make it a criminal infraction. Then those fines, we don't have to try to enforce a judgment to collect on those fines. They're a criminal fine, and they're enforced through the court system. Again, not necessarily quickly, probably at small increments like they are now, but we don't have to, you know, garnish a bank account or wages to try to collect them. There's also the possibility of jail time. And, you know, that might reinforce to some that, you know, this isn't just a fee to be allowed to, you know, keep a nuisance on their property. So, you know, that's an option as well. And then if we filed a second offense, for example, rather than filing the second offense as a second civil offense, we file the second offense as a criminal offense.
Yeah, now that was my question. Do we, if we were to change the ordinance in order to reflect what you were just talking about, Pat, that then would forego the second notice that we would do? Or do you suggest having that second in place and then use the criminal charge as a third offense if they haven't done anything within a time period? Or do you think we should just expedite the process and use that as the second violation as we have it in the ordinance right now, instead of being civil, being criminal?
I mean, you know, we're stuck with trying to figure out what to do with the second, with an ongoing nuisance after a first has already occurred. So, I mean, I think we're talking about what to do with a second complaint. So that's where the solution or the answer needs to be made.
Okay.
That's my opinion on that. But we could do that. Again, I don't know that gets it cleaned up any quicker. I mean, I was talking to Mike Brown, who's on the Zoom call with us. We've talked about this before I put this memo together, and you know, he has experience in both as a past in this office as well as city attorney for a number of the small communities around Jefferson County. And you know, his answer to me was the only 100% way to make sure that it gets cleaned up is for you to do it yourself.
And on that note, it sounds to me like if the road department's not an option, that's something we would potentially need to contract out to do.
Which we did for Boyd property. But I don't know if Bob's still available anymore.
Well, I'm sure there's others that would be interested in that.
My feeling on it is I have no problem with adjusting the ordinance or rewriting the ordinance or whatever to make the second offense a criminal penalty and giving these individuals an opportunity, you know, with a little more teeth in it. But I honestly, with all due respect, do not believe that Marty Rainbow is going to give a flying rat's behind about a criminal penalty. And if we put them in jail, this doesn't get the property cleaned up.
Right.
And it also doesn't pay fines.
Right. And so the only, I hate to say it this way, but the only hope that we probably have of recouping any money is if those properties in the first round don't sell at a tax sale, that we buy them at a tax sale. If we've ended up cleaning them up. And so at some point we might be able to sell it at a reduced cost.
Right, and if we can sell any of the equipment. So that's the question, because, you know, there could be some equipment or scrap iron or whatever on a lot of those that could add up, obviously.
But a lot
It
of
can help.
times when you contract with someone to come in and clean a site up, then all that material becomes theirs, their possession. So you won't get any recoup from taking it to a scrap yard or something like that, because that's how they're going to make their money.
And then it'll be cheaper.
Right,
Well, that's what the property that I was telling you about up in Abington, that's exactly the arrangement that they entered into, the individual that grew all that stuff. Was able to dispose of it and receive some income off of it.
right.
I know it's a long drawn out process, and I know it's not obviously the best case scenario. I think, Pat, plug your ears for a second. I think that we should probably look at the properties and pick and choose initially out of the gate which ones we think we might be successful in recouping it through a tax sale. There's several properties I think that if it went on to the property taxes and were not paid and sold at a tax sale, I think there's some out there that might be more valuable, if you will, than others.
Well, and I think we would also just need to make a list of criteria. That could be one of them, but another criteria could be how long they've been a nuisance. You know, that's going to get them certain points. So we have some quantifiable thing, otherwise we're going to get back to the subjective.
Well, it's just like the Boyd property. If we go in there and tear that house down, which is exactly what needs to happen in that big tree removal. Unfortunately, the property owner is going to be tickled pink about that because two things are going to occur. It's gotten cleaned up, property taxes are going to be released, and he has to stop paying the sewer bill. Just saying.
That's another criteria.
Right. And he has enough financial wherewithal to pay his property tax, even if we put it on. You know, that would be the one thing he would have to do, is he would have to pay it if we specially assessed his property tax. I think he probably would, maybe he'd fool me, but if we own that whole lot or that whole thing up there, and then, you know, you might be able to recoup a couple, $3,000, $4,000, $5,000 between the two. It's going to be an expensive process if in any direction we go short of repealing the ordinance. Okay, and my only take on that is I don't want to repeal the ordinance, but if we're not going to force these people to clean the properties up that aren't cleaning the properties up after they've been cited, then why do we have it?
Yeah, I kind of feel that way as well, but I think we better have a more in-depth discussion about this at a later time. We're not going to determine anything here today as far as what we're going to do, but it's been a good discussion as far as what the county's position could be from here into the future.
Well, and potentially, if we chose to.
Can I ask a question?
Yes.
Because I know that Bruce and Kent and I have been having the conversation about, well, what do we do with this? You know, there's 3 or 4 particular properties. What do we do with these now? And the answer that I've been giving to them is, you know, our client needs to decide that. So it's fine to push the conversation down the road, but I mean, would you prefer to have conversation about specific properties so that you can give guidance as to what we do next? Because we're just kind of in a holding pattern on a handful of these.
Well, I think that's a good question. I think that's probably a direction we ought to move, at least in the beginning here, but we need to also have the long-term discussion of what we're going to do with the ordinance itself, whether our remedy moving forward, as we're talking about right now, would work or not. Because if that works, then there may not be any need to change the ordinance or anything. But if it does not, then there will be something that we need to do with the ordinance. So I think at this point, Pat, you're probably correct that it's better to give direction when it comes to individual properties at this point in time, and then move forward on the bigger picture as we get there.
Maybe that involves we go on a road tour and look at the properties together. Since there's just 3 or 4 that are, it sounds like the priority ones to act on. If we choose to go ahead and clean those up, then we'll have a pilot study, so to say, of what it's going to cost. So we would know for the long-term picture, because that is where it's going to affect budget. If we say, okay, we're going to do this, then we need to figure the budget out at budget time to do that.
Well, I still, and that's fine, but I still think that first order of business is to send out a letter now, giving the property owners notice that they have 30 days to mitigate the nuisance in its entirety, or the county will take steps to remove the nuisance. And then they're on record, or we're on record, and allows us to proceed to the next step. If we don't do that, then we're 30 days out from whenever we decide to do that. And you have a road tour and you go, look, the only other thing that I put to that is that if we send notices to everybody, then yeah, you may pick and choose to say, well, okay, we might get our money back out of this one, so let's do this one. That's being subjective, it's not being objective.
Right,
Right.
right.
But that being said, if we send this notice out to everybody, and I guess beauty's in the eyes of the beholder, the folks down in Glasgow want that property clean. That just because it doesn't appear to be as much of a nuisance to us as maybe the one up in Abington, I don't think is the right approach. And so, and I have no problem going to look at the property. It's like the one clear down in the, there's nobody there except that property owner. So realistically, and we had a complaint from an adjoining property owner, but there's nobody there. We had some stuff in the right of way. I don't know if he came in and met with us. We gave him an extension to no avail. So that's, listen, I'll be the first to tell you, I don't want to spend the money, period, to clean them up. I just don't want to do that because I think that it's going to be a budget buster. But that being said, those people that have spent the money and are looking at a nuisance property that we're not taking steps to mitigate is problematic for me. And that's why I asked the question, and I understand that, we need to have more discussion before we start taking possession of property. But I also think that we need to, at the very least, send out those letters, whether they have to be delivered by the sheriff or by certified mail, stating that in 30 days, we will begin to take steps to mitigate the nuisance. And at that point, then Pat, correct me if I'm wrong, at that point, we've given them notification. And then we can and if we can take possession of that property or allow the person or persons cleaning that property up to take possession of, the vehicles or whatever the case may be to help offset some of our, and we start doing one or two and the word gets out that we're serious, maybe the rest of them will take care of themselves. I don't know the answer to that. I mean, we've been successful, Pat or Bruce and Ken have been successful in getting properties cleaned up. Some people have taken notice and have made great strides. I'm very appreciative of that. But we've got others that are thumbing their nose at us that don't even show up in court. And I don't know. You've heard my story, Pat. Am I anywhere close to being even just out in left field? Am I in the same ballpark?
I mean, that is a solution that is available to us, and it's just a matter of the hard part here is that, as I've said already, it's not up to Bruce and it's not up to Kent and it's not up to me. It's up to the collective board, and we'll do what we are instructed to do. I'll send out an updated list on this email that I sent to you. I'll send it to everybody, kind of let people know where we're at, so you have an idea of what cases are the problems currently, and then that'll maybe help focus the discussion in a little bit.
Can we have Bruce draft a letter and send it to you, and that we can, and this would be kind of like this is your final notice sort of thing, and to send out to whether it's property owners that we choose or the property owners in general that have not mitigated the nuisance, so that it's accomplishes, or I don't know if it accomplishes anything, but at least will be within the legal parameters.
Yeah, I mean, the letter's not going to be hard because it's essentially the same letter that we send out when we end up taking folks to court. It's
Okay.
doesn't require a separate letter or a different type of letter. It's all, this remedy is one of the remedies that's available rather than citing somebody. But
Okay.
the initial notification from the county is basically the same.
All right. And then we would be within our rights if the board chose to do so. Whichever property we happen to choose to mitigate first, once we send out that quote final notice, then we're free to move forward.
Right, under the way that the ordinance is written, then you can move forward after the period of time passes. I think it's 30 days. You can move forward to mitigate it on your own.
Okay.
All right, do we have any more discussion on this? Does the board have a desire to have Pat send a notice of 30 days of right to cure the situation that's going on their property?
Yeah, I would and make a motion that ask Bruce and Pat to make any tweaks that might need to have to be, if any, done to the letter, and then get together with the properties. I'm sure Bruce knows which ones we're talking about, and all the ones that have not complied, and send that letter to. And then with an updated list from Pat, we can look at it and say, so
So, hey, Pat, do we have to give a second notice to give an extension of 30 days?
I don't know that we have to, but it's I think I want to, just to eliminate that as a potential argument down the road.
Okay.
Yeah.
I agree. I want them to know that we're going to come in and clean it up because they have. That's what I want that last letter to say.
Okay.
Is that this is it. We're done thinking. We're going to come in and clean it up if you don't. And we're going to apply that to your property tax.
Go ahead and share with me, Bruce, what I know you have your letter from the past, and maybe we'll add a couple of tweaks to it just to emphasize that point. But it shouldn't take long.
It's basically paragraph F of the nuisance ordinance. We'll just tweak that, and we're going to be good to go.
Yep.
And then you guys will get an update between the two of you, an updated list to send that out to, and then the board will get the updated list.
And he'll have it since he's the one that's filed.
I want to send it out to all of them, then have it mitigated, but the board then will look at the list and see where we might want to proceed on a specific property, if at all.
But I'd like recommendations from Bruce and Pat.
Okay. I believe I have a motion from Dimmitt to move forward with direction to our county attorney, Pat McVan, to follow through with a letter to property owners who have not truly complied with their nuisance ordinance violations. Do I have a second on that? I have a second from Sandquist. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. Thank you, Pat.
You're welcome. I would say, to sort of clarify that motion, that essentially you've authorized us to send a second notice and emphasize the remedy we have to clean up the property on our own, and assess them the cost. So
Okay.
that's what we'll work on, and we'll identify the folks that's appropriate to do so with, and we'll kind of go from there.
Okay.
So you guys know, by the way, I'm going to continue listening in, but I've got an appointment coming in my office at 10 o'clock, so I'll probably leave your meeting early.
Sure. Okay.
Thanks, Pat.
Thank you, Pat.
You had something, Scott? I thought.
Okay, we'll move back to discuss and consider courthouse vendor list.
All this was we had an issue. It's nobody's fault, which is one of the.
Thank you, guys.
We had a major water leak downstairs till we figured out the pump wasn't working, right?
Right.
And it turned out that Jay wasn't available. So I was just wondering if it would be appropriate and possible if Dave could compile a vendor list that that, whether it's on his desk or whatever, or each of us would have a copy, that in the event that we can't reach somebody, we might be able to reach somebody else.
Right. And that's a good thing.
I would have,
Good idea.
if I would have, now Mark took it upon himself, and I don't mean that in any sense other than he had phone numbers to call some people. I was gonna call Darren, but Darren's not always gonna be available or and so.
And this was a case of, the leak was caused because there was a misunderstanding between parties as far as when this pump was to be turned on and in operation. And so water went down the sink, and then it filled up the little holding tank that's in the ceiling. Now down there, there was a drain pipe that was removed. I think you guys probably remember where the location was that was at, because that particular drain went into one underneath the concrete floor that has deteriorated to the point that it can't be cleaned out adequately for the water to go through. And so this was a method to be able to make a single sink work, and the water came because of that. It wasn't because there were pipes up there that weren't done up or anything like that. It was just a matter of the pump needed to be plugged in, and the plumber that put it in wanted to have it checked one more time for leaks before it was plugged in and put into use. And so that's how that event took place. And you're right, Lee, it is good to have a vendor list that in the auditor's office, so that we know who can be contacted, and then we have their name and number along with it. I know that Dave has got a lot of that stuff right now and calls people based off of who has done work in the past and how that has worked. And
And in 99% of the cases, Dave's gonna be here to make the calls or take care of the issue.
correct. This was a case where Dave was not in work at that day, and so we had that incident happen. And I know it seemed like a ton of water at the time, because that's the way it happens, but it was not because of any pipes that were leaking. It was the fact that the pump itself wasn't moving the water where it was supposed to, and so it was going out its overflow.
And the cord was hanging down from it. And
Yeah.
you saw the cord. Logic dictates it's supposed to be plugged in somewhere.
And there was an outlet up there to plug it into. It was just the case where the plumber didn't want it plugged in until he had a chance to check the integrity of the work that he had done.
I turned the pump on, it worked like a champ.
Yeah, well,
So that was good news.
yeah, and it's working right now as far as I know. So, all right, that's a good discussion on that, and we'll move forward with trying to do that. Let's see, we still need to go back and review this resolution for reduction in the environmental health budget. Did
106,000 was the 2020 budget. What you had approved for his budget was $90,016 for 2020.
Right, okay.
okay.
Which is the portion, so that portion, it remains the same. That was what was certified, the 90,016.
Mhm.
Okay, good. I make a motion to approve the reduction as presented.
Okay, I have a motion from Dibbit and a second from Sandquist to approve the reduced budget of the environmental health by $7,386. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. Okay, we'll move on then to committee reports.
The Rust Board meeting and Wednesday, and the board has submitted a letter to the Jefferson County Public Health through Resolution R13-21 to withdraw from the 28E agreement we have with Public Health presenting not available vacation or whatever. And so I just want to bring you two up to speed or into the equation so that you're aware if you get questions. Trying to approach this in a tactful manner. Basically what it amounts to is that Russ has some concerns about policies and procedures. They don't believe that the code is being followed to the letter in terms of permitting septic systems, and don't want to be placed in a situation where a contractor, for example, has been given the go-ahead on one thing and Russ doesn't feel that that is the appropriate direction. So they decided to just take themselves out of the equation. We have not since 2018 had an occasion to be over here anyway, so it's not like it's going to be.
Have you talked with the chair of public health about that?
I have not, no. I don't know whether Bruce has had any conversations, but given the circumstances, maybe about 3 months or so ago, I don't want to throw stones. I don't want to cause any problems. I figure it's, the letter that Bruce sent out will be self-explanatory. But you guys probably wouldn't see the letter, and so I just wanted to bring you up to speed so within 30 days, which is according to the 2080, that we will withdraw from the 2080. And just to be sure, or to emphasize, this has nothing to do with the decision that the Board of Health made regarding the sanitarian issue. It just has to do with procedural mechanisms that Russ is uncomfortable with. It does not mean that he's operating outside the code. We just don't believe that it's being, we'll just leave it at that. I also had an ambulance board meeting. We had the attorneys draft up a lease agreement with CARE so that we could provide insurance on our rigs. Felt that it was much more economical to go through CARE insurance carrier because of the number of rigs that they have. And so that agreement was signed by both parties, and we should see our rigs this week. I had a conversation with Mike from the Fair Board about parking the rigs out in one of their buildings out there until October 1st. He didn't see it as a problem, but he would have to get with others, and I told him that we would, not us, but the ambulance board would, pay whatever the going rate was for that period of time, but no later than October 1st, they would be out of there. And so when we get the rigs, we'll do a press release, a photo op. Exactly what day this week we'll get, I don't know, but I'm sure Julie's been in contact with Kevin to make those arrangements. Yeah, we will. So I'm excited about that, and I think basically that's it.
Yeah.
Okay, I had seal, and there are some CARES Act dollars available, so I sent Dr. Knoll that information. Schools and current mental health providers can apply for the funding, and we want to see it used up. So hopefully they will apply for that. Also, the SEAL region contract with Southern Iowa Mental Health for access centers, and this is the first one in the state. So we have a virtual contract, so we don't have to build our own, because every region doesn't have an access center. So that is actually a MOU is what it's going to be. And I talked with the chair of the Historical Commission, because we all got an email about that. And it just sounds like in about 2016, for whatever reason, somehow the paperwork didn't get in to make that certified. So she's doing a little research on that. So.
Okay. All right. I had a DCAT meeting on September 2nd. We went over a PowerPoint display that really helped me understand more how the money is being spent and where it's being spent. which is a really good thing. It lessens my amount of confusion that was going on, especially with the fact that starting in January, immediately in March, we no longer had any meetings for a while because of that and COVID. So I feel more comfortable with it. I do have some paperwork that I need to fill out for that committee yet and get it returned. It's a survey, more or less, of what each one of the board members knows and what they identifies what they don't know or don't know how to work with, and we would get help in order to be able to do that. Then I was to have a meeting this Wednesday with the SEMCO board. We have chosen to move that meeting to the 21st of October, as we had no major points to discuss at this particular meeting coming up. Normally there's a scheduled meeting for the third Wednesday of every month at the landfill, but operations have been progressing so smoothly up there. There really isn't a whole lot to be able to put on agendas, and so we wait until we have a little more to go along with it. And so again, we won't have our usual meeting for the month of September. We'll wait until the 21st of October to have our next meeting. Tomorrow morning, I'm going to be on the Spotlight Show because it's the third Tuesday of this month already, which doesn't hardly seem possible. But I'll be on the show tomorrow morning and discuss what has been going on for different updates here in the county.
I had one more meeting, workforce development, and we're back to looking for a fiscal agent. We've had a couple people, our places interested, so we'll see more. The one that was interested, Buffalo County Auditor, some of the supervisors didn't want the person to do it, so.
Okay.
That reminds me, I got a call to Buffalo County Auditor. I got a check in the mail the other day for $8.50.
Right.
Because when my mower was stolen, they had to pay me the $500 deductible. The people that stole it, the person that stole it. So that's my third check totaling $15.50. And
How
on this
many years ago was this?
2, and on this check was stamped restitution paid in full. I want an answer for that.
Yeah, okay. Well, that's a personal
Well,
issue,
just-
Lee, but yeah, thank you for that. And I'm sure everybody thanks you
That's a
for
public
for
comment.
knowing
That's right,
that.
that's a public comment.
So, and again, we're moving into public comments. Is there any other public comments that anybody wants to express at this time? Hearing none, we'll move on to allow claims and approve reports. I have a motion from Sandquist, a second from Dimmitt to approve the claims and reports. All those in favor say aye. Aye. All those opposed, same sign. Motion carries. The last item on the list is discuss and consider nuisance properties, but I think we went over that very thoroughly earlier. So we can move on to a motion to adjourn this meeting. We will reconvene at 1 o'clock this afternoon to canvass the school election that happened this past Tuesday. So I have a motion from Dimmitt to adjourn.
Second.
Second from Sandquist. All those in favor say aye. Aye. All those opposed, same sign. Motion carries, and we will return at 1 o'clock here in the supervisor's office. Thank you.